Friends, taking this discussion forward, and while I was talking about trying to evaluate modern elements of understanding what goods are, today, when we say goods are mobile property, one of the interesting aspects for us to consider is intellectual property. Now, friends, intellectual property is new kind of property. It is intellectual in the sense that it is something that you create, unlike what we had traditional property in terms of mobile and immobile. Immobile was land and house. Mobile was everything that was tangible in nature. But intellectual property may not actually have tangibility. But yet, we call it property and we have given it rights. Rights such as patent, trademark and copyright traditionally as individual rights or even industrial design as the case may be. And then we have community rights like, say, geographical indication and so on and so forth, right? So, including plant varieties and others. So, there are so many of these intellectual property rights that can be created. And whether IP can be considered as goods. Now, this is a question that has been very important because of several reasons. First and foremost, you will notice, friends, when we talk about intellectual property, if it is having attributes of property, and if it has economic value, which intellectual property definitely has, because it is something that you can exploit in the market, you can make economic gains from the same. So the first question that people did raise is, can I pledge these intellectual properties with a bank and raise some kind of loan? Now, if you go back to the discussion on pledge, friends, you will understand that pledge was only of goods. Mortgage is immobile mostly and pledge is of goods. So if intellectual property is goods, it can not only be pledged, but please note it can be sold or that can be imposition of sales tax as well. Because we don't use the word sale under intellectual property. Usually the word that is commonly used is assignment. Or licensing as the case may be. Licensing is supposed to be kind of the right to use, whereas assignment is like a sale where you not only transfer the right to use, but you also transfer the rights absolutely in that intellectual property. So the question has been answered by the judges and they have said that any transfer of rights to use the intellectual property is considered as a deemed sale. Now, this is something that was brought about in the constitutional amendment. And if you read Article 366 of Clause 12, you will notice that the Constitution has said that if there is any transfer of rights to use, that can also be considered as a sale of goods. And the state governments can actually tax the same. So, from a taxation perspective, intellectual property has been considered as mobile property. This is something that can be taxed as well. So, we have to understand that the nature of modern property is also considered over here. Now, going further, coming to the most probably amazing case or interesting case that one would like to read is the Tata Consultancy Services versus the state of Andhra Pradesh. Now, friends, this case decided in 2005 by 5 judges. The main contention of the issue in this case is whether software can be considered as goods. Now, software, friends, is very integral. I think I am doing the recording on a software here. It is called the Camtasia software, which NPTEL has subscribed to. This probably course is on a platform which is a software. And most of these companies say that the software is a product. They consider that this is product development. And then yes, of course, once the software is developed, then you have to maintain it, you have to service it, you have to upgrade it, so on and so forth. Today, most of our even smartphone runs on a software, and then you have antivirus as another additional product that is also given. Most of our desktops have MS Office. Then we may have some kind of an Internet Explorer or Mozilla, some other softwares to actually run our system. Today in our phone, you will notice that there is a software in terms of an app, and we download this app, we do payments on this app. So the app is also one kind of software in which services are actually given to you. So the question is, when these companies, which are huge in number in terms of the kind of transaction value, the terms and conditions that they establish, the kind of economic consumer activity that they contribute to, you will notice that the software industry being so huge, the question very clearly says is what kind of contracts are they making and what kind of tax are these contracts, are going to attract to. So, of course, the state government said, look, software is goods, everything is good for the state government. And hence they said, look, we should be able to tax it. And this is nothing but sale of goods, and sales tax is applicable to software contracts. To which TCS, Tata Consultancy Services, they probably disagreed and they challenged it. They said, look, we are only giving services of software because, we are writing a code, an algorithm is being made, and that is just being used. And hence, it's not something that is tangibly delivered to the customer. And hence, we have to say that what we are doing is service and not sales. So that was the argument of TCS, and it went to the court, and hence the court had to decide what are these softwares actually doing, right? What are these companies doing? What are the nature of this contract that is being agreed to? Now, the court in this case, at a huge length, did discuss a lot of things. And they brought in jurisprudence from other jurisdictions, including the United States, where a similar challenge or a similar problem had arisen. Now, what did the court do is they actually looked at, say, water as some kind of an analogy that can be drawn and compared to software. They said, look, water that is flowing freely in a river, right? It is not considered as goods until and unless it is actually trapped or abstracted into a container. So once water is put in a bottle and it's sealed, and then you brand it, say Bisleri water, that becomes goods. And hence, once a software is branded, it is abstracted, and it can be put in some kind of a device like a bottle or a CD. It can be stored in that CD in terms of the number of MB or GB that it can be measured in terms of storability. Then it can be possessed, it can be delivered, it can be transferred. So the CDs can be brought and sold. Then what is in the CD, what is in the container, what is branded, and what the courts use this very interesting term called capped, uncapped and capped. So what is capped is definitely should be considered as goods because it has a marketability, it has a brand image, it can be sold off the shelf. And hence, in the TCS case, very interestingly, the court says that, look, branding and unbranding is not so very important, though in one sense it is. But what is important is that if the software can be delivered, transferred, stored, and processed, then that will create the software to be good. So what was rather sold in a CD was considered by this court decision as goods, and what was probably customized maybe could be considered as service, right? So I think that is how the TCS judgment was evolved, and there was a clear segregation of the software contracts as some that can be considered as goods and some that need not be considered as goods because they're customized to the customers, and these are mostly the contracts that TCS was entering into. However, please note, the TCS judges did not look at the word sale. Now, this is important because sale is yet another definition, because look, you can still be under the definition of goods, but the point is, are you under the definition of sale? Now, that's a different test altogether, right? The reason why I'm talking about that is, something that we will visit very soon. We will talk about it very soon, but right now we are only just talking about the attributes that a thing needs to be considered as goods so that the Sale of Goods Act can be made applicable. Now, please note, friends, when we talk about goods, there are three things that one will have to understand as goods, that goods can be divided into these categories. Certain goods are specific, right? They are goods that are present, they exist, they are identified, and they are asserted. That's what a specific goods is. You clearly know that the goods are there. That's what the Sale of Goods Act says. Now, why I'm talking of specific goods is because, friends, you can have a sale of goods contract for specific goods because the goods are existing. They know they have been identified to be given to the buyer, right? Now, say in a sack of say rice. What is specific goods? Suppose you just want 5 kgs of rice, 5 kilograms of rice. If I have taken 5 kilograms and specified that these are the 5 kilograms that I am giving to the buyer, then it becomes specific goods. Otherwise, the goods are unascertained. So the goods are present but not ascertained. It means it has not been identified as the goods that will be given to you. For example, you want to buy a car. You have specified which car you want. But once you go to the car showroom, which is the car that has been identified to you, that would be the specific goods. Till then, yes, the cars are there, but which among them is what the seller intends to give you becomes something that is relevant and important about how the contract of sale of goods had to be made. Also, you will notice that there is this very interesting concept under the Sale of Goods Act of future goods. Now, I've already given you an example of what I call as contract farming. Now, can there be an agreement to sell for future goods? Please note the Sale of Goods Act says, yes, there can be a proper contract, and that proper contract is the agreement to sell, and that is enforceable, but however, it is for future goods. Now, until you have the goods ascertained and specific, there cannot be sale of goods. There can be an agreement to sell for future goods, but there cannot be sale of goods. So sale of goods can only occur of goods that are ascertained, that are specific. That is how the condition under the Sale of Goods Act comes into place. So goods have to be ready for deliverability. And please note, the Sale of Goods Act also further adds and says that it is the duty of the seller to put the goods in a deliverable state. And he can put the goods in a deliverable state only when he ascertains what he will deliver, what he intends to pass to the buyer, and the goods have to be existing and they have to be specific as well. So that is how the test on the sale of goods finally occurs.